Hello. Oh, wow. Hi, everybody. Kia ora. 50. Okay, we're just going to give everyone a few minutes to log on.
Watch the numbers creep up.
That's not terrifying at all.
No.
Wow, we're so grateful for all of you giving up your Thursday afternoon to hear us talk.
Share our wisdom.
Such as it is. How's that weather, everybody?
What else do you do to kill the silence?
Got any jokes? That's a good number.
I like this number.
Welcome to Privacy Week 2023. Hi, everybody. We're just waiting for everyone to sign in, and we've been told that we have to narrate. So here we are, narrating.
Jen says it's fine and sunny in Greymouth, but very cold.
Kia ora, Jen. Yeah, it's freezing here too.
Yeah. Thankfully, no longer hailing though. Very grateful for that.
So many attendees. Oh my gosh, I'm humbled.
Cold in the Hawke's Bay as well, says Melanie. Yeah.
Kia ora, Melanie. Okay, we're being told we can probably start now. So, shall we begin?
Yep.
Kia ora. Kia ora koutou. My name is Riki Jamieson-Smyth, and I am the Manager of Investigations and Dispute Resolution at the Office of the Privacy Commissioner.
And I'm Sarah Warburton. I'm a Senior Investigator here at Privacy Commissioner as well.
So thank you everybody for joining us today for this session on how to do Principle 6. We acknowledge that the headline and the subject matter of our webinar don't quite match up. So what we're going to do is we're going to talk about how to do Principle 6 and how to hopefully avoid a complaint to us.
Or how to put yourself in the best position to respond to a complaint from us.
Yeah. So we'd also like to begin by, we only got the attendee list this afternoon, and we'd like to acknowledge the experience and the expertise in the room. There's a lot of you out there who know a lot about privacy, and we're really grateful that you've decided to join us. So we had initially pitched this session at quite an introductory level, and so while we've now pivoted, given the nature of you who are joining us this afternoon, we acknowledge that some of this is going to be quite, maybe, not new information for some of it. We'd also like to caveat that our process is focused on conciliation. We're here to resolve disputes. And when we are undertaking an administrative review under Information Privacy Principle 6, or one of the Rule 6s, we do apply the law as we see it, and we understand it. We also understand that we don't always have access to all the information or all the background that you have as respondent agencies. And it's also sometimes the case that the tribunal or the higher courts don't agree with our findings. So the objective of this session is not to be the be all and end all of Principle 6. It's to help agencies understand and comply with their obligations under Principle 6 and Part 4 of the Privacy Act 2020, avoid a complaint to us, and then work with us to deal with a complaint as quickly as possible if you can't avoid a complaint, because we acknowledge also that it's sometimes an impossible task to avoid escalation. And we also acknowledge that the law in some parts as it's written is not easy to understand or to apply. So all of that said, we'd love an open discussion. I can see people are using, oh, Justin, you are worthy. Hi, Sandra. We'd love this, given all of you experts out there, please, we'd love this to be an open discussion. So please use the Q&A function to ask questions, and we'll use that to kind of go back and forth. Okay.
Yes, and Mandy, we will absolutely cover the introductory level stuff as well. We want this to be accessible for everyone moving forward.
Yeah.
So we're going to start at the very beginning what do you do if you get an information request under Principle 6? Principle 6 is one of the core rights under the Privacy Act, and it comes in two parts. Do you hold personal information about that individual? And if you hold that personal information, are you going to give them access? People have the right to request that access. Obviously, that's caveated, and Riki will go through that a little bit later on. But sometimes it's a bit daunting when you get a request, particularly if you're not from one of those big agencies that has a process in place to get requests. And it's like, how do I begin? And we want to say, treat humans like humans. Open discussion is honestly the easiest way to get through a request. They'll often come through, they may come through from individuals where you've had a bit of a contentious relationship. There might be a bit of relationship that has broken down, or someone might just be a bit confused about what's going on. I just want to find out what's happening.
The world is a bewildering place.
It really can be. So there's a number of key questions and that you sort of need to think about at the beginning of the process once you've got it. Firstly, do you know who this individual is? Can you confirm their identity? Do you need to ask them for ID? Are you sure that they're a client of yours? Do you know what's going on? Once you've confirmed that, you can then start figuring out, do I actually hold the information that they're asking for? If they've gone to the wrong place, if say they've gone to the wrong district of Te Whatu Ora, or they've gone to Otago Tamariki rather than MSD, direct them to the right place. Be useful, be helpful. Don't just ignore the email and let it sit because it's a little tricky. The best thing is just to talk to them and let them know what's going on.
Preliminary thing there too, that there's a slight change in the transfer provisions of the 2020 Act to the 93 Act. Under the 93 Act, you could just transfer, say, right, I don't hold this information, but I know that some other agency does, and you just had an obligation to send it over there within 10 days. The new Act, the individual actually has the right to say no to that transfer. So just keep that in mind. If the individual declines your transfer of the request, you then have to respond and answer make a decision on the request in line with the other obligations under Part 4, and that might be to say that the information is not held.
100%. So once you've confirmed you have the information, you know who they are. Next question, do you understand what they're asking for? Again, be reasonable. A lot of these people, they might not be able to know the language that we use on a day-to-day basis or recognize how we frame things. If they're asking for information and they've used the wrong terminology or the wrong phrasing and you're not quite sure what they're wanting, ask them. It's really easy and it's going to make your job a hell of a lot easier down the line when you're trying to gather and compile all that information. If you know that they've asked for everything you hold about them, but they don't want copies of the emails they've already sent you because they already have that, that's going to save you hours. So talk to them, narrow the scope of their request, understand what they're looking for. And if they've used the wrong terminology, oh, we don't label this as a complaint, we label this as a query. Are you looking for the queries that you've made to us? That's going to make your job so much easier.
Yeah. This might be a good point too, we've received a question. I've recently received an IPP6 request from a law firm for their client citing the Privacy Act and giving 10 days to provide the information. I'm aware of the PA timelines, which is obviously different, 20 working days. What's the best way to respond to that? So as you know, the Privacy Act allows a requester to request urgency, and there's a case that you can look at that the tribunal set out what a request for urgency should look like, and that is Turner and University of Otago. You should give, if you've received a request for urgency, you should consider it, comply with it if you can, and if it's going to be difficult to comply with, you can ask them for reasons for that, or again, as Sarah says, work with them, narrow the scope of the request, see if you can give them the information that's of the key importance to them first within the timelines, but it's not an interference to refuse a request for urgency.
Yeah. The other thing you should be doing really early on is acknowledging the receipt of the request. Let them know that you've got it, that you're working on it, and the anticipated timeframes, if that's going to be you're accepting their request for urgency or whether it's just going to be within your 20 working days. That gives them something to know that, hey, it's there, it's being worked on, I can just let it sit for the next month. And you're not, hopefully not going to get a million emails following up, which, you know, we all know can happen. Coming back to the identity of the individual, making sure they have the right to request the information. If they're asking on behalf of someone else, do they have the appropriate authority to act? Parents can often be a really tricky situation because there is actually no automatic right under the Privacy Act for parents to get access to their children's information, with the exception of health information when the child is under the age of 16. So if a parent is coming through and asking you for information about their child, and the child is of, 14, 16, 18 years of age, start considering, are they actually asking for that information on behalf of their child, or are they asking for that information on their own interest? Because in that case, it might not be a request under the Privacy Act. Use your common sense. If you're not sure, ask. And if you're still not sure, come talk to us. And while we might not be able to give you a legal answer, we can definitely steer you in the right direction.
And remember as well, for those of you who are at public sector organisations listed in the schedule of the Ombudsman Act, that there is a difference between a Privacy Act request made by an authorised individual and an OIA made with consent, because the withholding grounds under 92A and 53B are different, right? So if someone's making a request, if I'm making a request for Sarah's information and she's given consent for me to use the information for my own purposes, you can potentially treat that under the OIA rather than as a Privacy Act request, because I'm the intended recipient rather than Sarah, even though it is Sarah's PI.
100%. The final thing is understanding, are they actually asking for their personal information, or are they asking for official information? That sort of all ties in. The other thing that they might be asking is just questions, and those questions might appear from the outset to be a request under the Privacy Act, but you can't use the Privacy Act to make an agency create information. So look at those questions. Be reasonable, treat them like a human being. Can you answer those questions in a way? Can you provide them with information? But that in itself might not be a request under the Privacy Act. And again, that might alter how you're going to respond to the request.
So a requester can't compel an agency to create information in response to a Principle 6 request, right? Or create information in anticipation. So always bring your mind back to, well, not always possible, but in a perfect world, turn your mind back to Section 42. You've got to give assistance, and if it's not a Principle 6 request, you still might be able to help them by answering their questions or helping them understand reasons that your agency has made a decision, but it might not be that you have to automatically respond as if it's Principle 6.
Yeah, we've got a really good question here. How would you respond to a request for all personal information held? That's really super common. People do that a lot, and people do have the right to ask for all information held. Again, recommend go back to the requester, acknowledge that you've received the request and help them understand what they're looking for. Try to narrow the scope, understand the timeframes that they're looking for. Maybe they don't want everything going back if you've been working with them for 15 years for that 15 years. So work with them, talk to them, and if once you've understood the scope, be real open and honest about your timeframes. As much as you can, just acknowledge that, yes, we've got the request, we're working on compiling the information, reviewing it for any withholding grounds, and we'll provide you a response within X date. That would be.
Yeah. Another really good question here about extensions. The Privacy Act at Section 48(3) states that an extension is effected by giving notice of the extension to the requester within 20 working days after the day on which the request is received. Does this require the requester to acknowledge the extension notice? And what if they disagree? So a requester doesn't have to agree to an extension. The Act acknowledges that an agency may need to consult, search, retrieve, redact, compile information in response to a request, and you don't need to seek their consent to an extension. However, you do have to be careful that you have to provide the information without undue delay. And if you don't hustle after you've requested for your extension and your extension isn't for a good reason, you may be looking at a potential breach of one of the 69 sections, whether you've actually refused the request or caused undue undue delay in providing the information. So it's more of an issue for our process or for the tribunal that once you've made a decision on the request that you've then provided the information without undue delay. I hope that answers the questions. Another question, do you want to take this one or shall I answer this one?
Are we seeing more information requests linked to mediations, PGs, etc.?
So we do see a lot of requests and complaints linked to employment matters and disputes. Generally, as dispute resolvers, we say that you don't necessarily need your full file to go into mediation. You should, obviously unrepresented, but you should go into mediation in good faith and trying to resolve the matter without necessarily needing to prove that on X date you were on sick leave or whatever. Of course, once something escalates past the employment mediation stage, the Employment Court and the Employment Relations Act has its own kind of, mechanisms for access to relevant information rather than personal information. But yes, we are definitely seeing an increase there, and we prefer not to be involved and create a burden for the parties in dealing with a parallel process when they should be just hopefully getting on and resolving the employment question.
Another question here about transfers. Should information be requested or transferred to courts, for example, to request cultural reports, JSNs, etc., under Section 43 of the Act? Does the 20 working days apply to the courts for a response? So courts aren't considered an agency for the purposes of the Privacy Act when they carry out their judicial functions. So any Principle 6 requests to the courts for any of that information which comes within that scope of judicial functions isn't going to be considered a request.
Yeah, so you can only transfer to an agency, and a court isn't an agency for the purposes of the Privacy Act is the short answer. So I would recommend just providing assistance and pointing the requester in the right place, but it's not a requirement under the transfer provisions for you to transfer the request under the Privacy Act to a court.
Yeah.
Okay, good questions. Right, so part 2. What is personal information? You might think that is straightforward, but it's not. And so obviously information that is about an identifiable individual. And so there's all kinds of, information on our website on what about is, whether it's a course of action, whether they only need to be able to identify themselves, whether the world needs to identify them, whether a photograph or a driver's license number or an address or a internet connection number is personal information. It's going to be contextual, but are they named, otherwise identifiable? Is it in their file? Can you tell who it is? From context, is it about them? We generally won't accept complaints that are about property or business information. And then you've also got to be alive to so much personal information is mixed information, particularly for you big agencies dealing with multiple people or files that are built around whānau. Information will often be about more than one person. And there isn't a silver bullet for that, unfortunately. I'm sorry if that's what you logged on for. Looking for the numbers starting to drop. I'm kidding, you're all still here. But it's on context, right? And if you know it's about them, don't try and withhold it without a withholding ground, essentially. We have got some reasonably recent case law from the High Court in Taylor and Department of Corrections, where Justice Gwynne was quite clear that administrative information, even if it is on a person's file, isn't about the person. So context is important, and you can't redact information in a way that makes the information unintelligible. So be consistent, be kind, and be really careful when you're balancing privacy interests. How would you consider platforms such as DataMind an authorized person for data deletion requests, or should the person? I'm not sure about DataMind. Is that one of those things where you can sign up and it sends an email to everyone in your address book? I don't know. I haven't looked into that. I'm sorry. Do you know anything about those?
I'm not familiar, but I guess, again, be reasonable. if you can reasonably consider that the request has come from the email address that you have connected to the individual on file, even if it has come through that third-party website with a request for deletion, perhaps you can treat it as a request. If you're not sure, go back to the individual and ask, would be my recommendation there.
Yeah, sorry. Yeah.
As far as charging goes, Stephanie, we'll address that in a little bit. So I'll make sure to get you back to your question there.
Yeah. Okay.
It's a sign up portal request to be forgotten. I guess the thing is, stepping away from Principle 6, there's no automatic right of deletion under the New Zealand Privacy Act. You can request for information to be corrected, and that does include deleted. But again, it just is be reasonable. Consider, do you actually think the request has come from the individual? Have they been hacked? Is it someone else? And making sure you're not deleting any information that you should be retaining.
But also don't retain anything you should be deleting. Like, if you don't need it, get rid of it. Don't collect it in the first place if you don't need it. Obviously, we've seen that a lot with what's going on in the news right now. But if you get a request and it looks legit-ish and you don't need the information, why wouldn't you delete it? Would be my question to you, I guess. Okay, so I think that's probably it under number 2.
Cool. So what is a decision? So this is sort of the process you're going through. You've got the request, you've accepted it, you know it's for personal information, you know that the requester is legitimate, they have the authorization to request it. How are you supposed to respond? So a decision, or what is a decision, and your process is set out in sections 44 onwards of the Privacy Act. Really recommend, if you get a request, take a look at those. If you get a request through our About Me tool, which is a tool we have set up on our website, which allows people to use a form through our website to make a request to an agency. And many of your agencies have provided us with really useful contact details to make sure we know that the request is getting to the right place.
Yeah, and get in touch if you'd like to be added.
Please do. We're always happy to do that. You'll get a link to this document, which we are currently working on getting onto our website, which is the sort of flow chart. We're going to make it prettier, I believe, on how to deal with a request for personal information. So what I was talking about and what Riki had just been talking about is sort of your initial request questions. And what we're going to look at here is the sort of processing the request. Do you have the requested information? Can you make a decision about the information within 20 working days, the transfer provisions, all of that sort of thing? So there are a couple of ways to respond to a request. First, that you do hold information and you're going to release it. That's probably the easiest. You just respond and you can release the information simultaneously at the same time as your response within that 20 working days. Often you don't need to have that separate decision or response there if you're just going to simultaneously release the request. If it's going to take you a little bit longer to release the request in that 20 working days, but you know you're going to release all the information, you just need to compile it. That's when you can acknowledge and confirm that you are going to release the request within that 20 working days, and then have your provide all the information without undue delay after that. And that's all set out in Turner if you need a bit of guidance there. The other option is that you don't hold the information. You can just, if you don't hold anything at all, that's a good option. Or you do hold the information, but you're going to withhold it. If you're going to withhold it, you need to let them know the reason. So what ground under section 49 to 53 of the Act, and the reasons why. So you don't have to be super specific because you obviously can't disclose the information about those reasons, but you do need to give something to people. And it is really, really useful if you can put that reasoning in a covering letter, because a person, if information has been withheld from them, they'll have the right to make a complaint to our office. And it makes everyone's lives easier if you keep excellent records about what you're doing, why you're doing it, and the information that you've withheld. So if we do have to review it, it's a really straightforward process.
Yeah. Yeah. So we've got a couple of questions here. I work for a professional regulator that receives complaints from the public. Kia kaha. Often at triage stage, we decide not to investigate complaints. Same. we often get Privacy Act requests from complainants who didn't get their complaints investigated for a full file on their complaint. Question is, if Jane Doe complains about John Smith's conduct, how much of the information about Jane Doe's complaint is personal information about Jane Doe? What about John Smith's response to the complaint? Obviously, there is the unwarranted disclosure exception, but what is the personal information? So this is a classic example of where it's going to be mixed, because Jane's feelings about the complaint about John and vice versa, and John's response to Jane's complaint are going to be about both of them. So you just really do have to analyze that line by line. Who is this information about? What was the context where you got it from? Also, it's really good. I know I used to work at a different complaints body, and we used to say right at the beginning, it's part of our process that we share complaints correspondence. So if you send us a complaint, we're going to send that to the person you're complaining about, natural justice. And same to the agency complained about. You give us a response, we're going to give that straight to the complainant. So if you set those expectations at the beginning, you've got to get out of jail free card. But if you haven't done that and you don't have secrecy provisions in your governing legislation, then you just have to analyse it and balance the privacy interests under Section 52.
Yeah, another really good option there might be providing a summary. Can you give them a high-level summary of what's been complained about, so they have the substantive information to know, but they don't have to necessarily get like John's feelings or
Are we going to answer Justin's question? We've got an answer for you, Justin. He's asking for our pet peeves as investigators. We might finish with those. Yes, we might, yeah.
I want to jump back to Stephanie's question about charging. So one of the other things is, if you are going to provide the information and you're not a public sector agency, you are allowed to charge for access to information reasonably. And so Stephanie has asked, they can require this to be paid in advance. What if a requester disagrees with the estimated charge and refuses to pay it in advance? Again, talk to them, understand sort of what's going on, but they do have a right to make a complaint to our office. And one of the powers that we do have is the commissioner can determine what the charge is. And once that's determined, that's it basically.
Oh, well, I mean, you can challenge us in the tribunal, right? No, they can't for a charging decision, can they?
So.
No, sorry.
But we have recently developed some charging guidelines on our website.
All Sarah's work, they're fantastic.
Super useful. Take a look. So you can find them under the Your Responsibilities tab. Your Responsibilities, charging for access. You'll get this sort of high level page here, which gives you your overview. And if you click into this PDF here, you'll get this lovely document, which includes a nice little summary of what you can and cannot charge for, what reasonableness looks like, some questions you can be asking, useful links to some cases and some case notes where we've determined charges, and then specialist information for health, for credit reporters, because you've got different rules, and then a charging at a quick glance that you could print off and have handy if you wanted to. Reasonable really does mean reasonable. We do have some numbers on our website which we've pulled from the Ministry of Justice around sort of what they think is reasonable, and that's again pulled from Official Information Act responses. They're quite high, and I'm going to be honest, in most circumstances we're going to recommend you go lower. There is a right of access to the information, and that is really key, and charging for access outside of what is necessary isn't going to stand. Think about what is the actual cost to you. Are you releasing on a USB, which is going to cost you money? Are you printing out a significant amount of documents?
Yeah,
those sorts of things.
I don't think we've done one under the new commissioner, but the former commissioner was of a pretty strong belief that the cost of a USB was about it in most cases. So yeah, don't charge unless you have to.
And if the person really disagrees with the charge, advise them of their right to make a complaint to our office, and we can get involved there.
Yeah. We've got a follow up about the data mining request for delete. Assuming we've verified the request, what's the obligation where we're required, including by funders, to retain some health information? So as you know, just confirming Sarah's point, there's no right to deletion under the Privacy Act, only a right to request. And if you've got obligations, and including some pretty significant obligations under the health, retention of health information regulations and the Health Act and all kinds of like way more important stuff than us, then you don't have to delete it, right? You've got to look to the other obligations, Public Records Act, whether you're required to keep company business information, that's all going to override a request for deletion under 7. So think about 9 and think Principle 9 or Rule 9 if it's health information, and then to your other obligations to retain records. Hi, Neural. Okay, so we've got a request for information about vexatious. What are we up to?
The perfect segue to your part on withholding grants.
Okay, so what if you don't want to give the information? And we understand that. First of all, treat humans like humans, separate the request from the requester. Often requests will come from people who your agency's got a contentious relationship with. They've got the same rights of access as everybody else. And you need to be able to apply one of the withholding grounds. What you need to do as well is unpack your assumptions, right? Think about when you're responding to a request, what has led to this? What am I contributing to the situation? Do I need to hand this over to a fresh pair of eyes to have a look at it? Because, you know, just a bit of a circuit breaker may help in diffusing tension. It may not help to diffuse, and sometimes you'll just need a withholding ground. So we've got some case notes on, I've got a request here about vexatious and trivial. We've got some guidance on that on the website. It's not going to come up very often or be available very often. And remember as well that it's got to be the request and it's not the requester. It's not like a vexatious litigant in the court. You've got to be able to show that the request is intended to vex, annoy, or otherwise derail the agency's processes or resources. Does that answer the question? I mean, hey, give it a go. If you'd like to, we'd love to. Use it, refer it to us, and we'll see. We'd love some more case notes on it, and we'd love to get some good guidance happening if we can, because we understand that the world is a bewildering place at the moment, and people's behaviour is not always the best. So we understand how difficult it is for you out there responding to requests. So other reasons that you might want to withhold information, just a point as well, readily retrievable has moved, right? It used to be a withholding ground and now it's a refusal ground. Yes, that is confusing. But the search still needs to hark back to Gary. It needs to be intelligent rather than mechanical. So what we recommend is keep a track of how you're searching. What steps did you take? Where did you look? Because just because it's technically retrievable doesn't mean it is actually readily retrievable. The amount of time and cost required to retrieve the information and the manner that they are stored are relevant factors. And for that, you can have a look at the tribunal case of Marshall and Idea Services. Just make sure that you find the privacy case and not the other ones. But also remember that you can't rely on poor information management practices to withhold information. Just because you don't have a good case management system or good naming conventions doesn't mean you can refuse a request. So keep that in mind when you're setting up a system or storing information. So the most common ground that we see come up is unwarranted disclosure. And we've talked about this already. It's where the information is about more than one person. And again, there's no easy answer. You just need to assess who the information is about. Sometimes that'll be line by line, and assess the privacy interests as you understand them. Make a decision, give reasons for that decision, and advise them of their right to complain. We'll ask, we'll check, we'll help conciliate if we can. And hey, if you get further information later about that changes your decision on the withholding grounds, then that's okay, because you can only base your decision on the information that you have at hand. So we do want you to try to understand the situation, but we also understand if you're not, we want you to do the best that you can. What other withholding grounds are there? Evaluative material has been coming up a bit as well. Also, we've been seeing a lot of legal privilege. In fact, I did a presentation the other day for someone who used to work at the Law Society, and she was absolutely gobsmacked that we were allowed to use our stat demand powers to request access to privileged material. We can. So if you have withheld information under the Privacy Act as privileged, as part of our investigation, you do have to provide that to us for review, and we will see, we look at the same tests for either legal professional privilege or litigation privilege as set out in the Evidence Act. But we do have to have a look to satisfy ourselves that you had a proper basis for the decision that you made to withhold the information. Maintenance of the law, don't use it unless you're a public sector agency, and also you have to tell us about the particular prejudice that you're trying to avoid. You can't just say maintenance of the law without any further details. What else?
If you ever get stuck and you're not sure, again, our website is a really good starting point. If you go to our Principle 6 page, which is the Privacy Act 2020, Privacy Act 2020 and the Privacy Principles, and then you click through to 6, you've got your different withholding grounds here, and like frivolous, vexatious or trivial, legal professional privilege. Oh, there we go. It's back. So say I clicked into unwarranted disclosure of another person's affairs, you get an overview of each of those principles, you get the Act reference itself, you get further information. So frequently asked questions, what does affairs mean? When will the other person's privacy be more important than the right of access? Links to case notes, other relevant sections that you might want to be looking at. It's super useful, and it's a really good starting point if you're not sure where to go. Harassment is another one we're seeing a lot of. This is obviously a new ground in the Privacy Act 2020. It's a little untested. We're still looking for how to apply it. We've had some good case notes come out, and we've got, again, some really good guidance here under what harassment may or may not look like, because again, it's a high threshold. But I think the key with each of these withholding grounds is you shouldn't be blanketly withholding information under these grounds. You need to consider the context of every specific request and request that's coming through. What is the piece of information before you, and how are you going to apply it in these specific circumstances?
Someone is saying that the Ombudsman recently used the term proliferators. Yeah, there are some quite focused people out at the moment who are very, very interested in getting access to information. We're seeing, yes, a lot of those. Okay, question regarding maintenance of the law. Could it extend to avoiding prejudice to an investigation whether someone had violated a statutory code of conduct, i.e. not a criminal offence, but a question of professional discipline? Yes, I think so. What does the law say? As long as you're a public sector agency.
Yeah, so prejudice and maintenance of the law is specifically about public sector agencies' abilities to maintain the law. So you do need to be able to sort of point back to something.
Hang on, no, it's not though, because it's including the prevention, investigation and detection of offences. So unless you the conduct that you're investigating is an offence under the code, then probably not.
So it's been used in like insurance investigations, that sort of things. That's sort of been able to extend to that. Oranga Tamariki can often use it when they're sort of investigating like child abuse and those sorts of things. But it is quite a narrow scope. So you just need to be careful and carefully consider. And if you're not sure, get in touch with us and we can give you a steer.
Yeah, we're never going to be able to answer the question, you know, say yes or no, but we're always happy if you contact our 0800 line or just flick us an email. We'll always try and give you as much guidance or point you to guidance as we can, because we don't want you out there you know, making wrong decisions without any you know, in the dark, essentially. Right. Have we answered all the questions?
I feel like we have.
Good.
That was sort of all we sort of had planned. We've got some key takeaways, which are really sort of the common sense things to consider when you're responding to a Principle 6 request, when you're trying to figure out what you're trying to do. And I think it does touch on Justin's question a little bit on what are your biggest pet peeves for an agency. So I guess for me, keep in touch with the requester. If you let them know what's going on but I mean, it doesn't need to be daily emails, right? But if it's going to take you longer and you know that at the beginning rather than like 25 working days in, let them know as soon as you can. It's going to keep you in goodwill with them and they're going to be more willing to work with you moving forward.
Yeah. Yeah. And I guess this kind of comes back to how to deal with the trivial, the vexatious requests as well. Complaints grow legs, right? The longer that you leave them. If someone doesn't hear from you, they're going to invent a story as to why, and it's normally not going to assign great, you know, motives to you. So keep in touch with them. Tell them what you're doing. Be honest. Give time frames. Don't let them spiral, because it'll just get worse. And that reality testing is so important. If what they're asking for isn't possible, tell them that kindly right from the beginning. Ask them what they're hoping to achieve. So in terms of pet peeves, we actually asked our team what advice they'd give to you, the people who joined the session today, and some of it was quite blunt, but I think you guys are ready for it. Someone's just told us that they like the banter, so we're going to continue with that. Figure out what a decision is and make it. Sarah's been through that. It's good. And if you're not sure, go to Turner and Otago. It'll tell you. Go back and refine a request. If it's too broad, it's too broad. That might not be readily retrievable. It's probably not going to include all personal information about them, but work with them, try and figure it out and actually focus on what the request is for.
Refining the request. Is there a specific time frame they're looking for? Like, because you know what information you hold about them. They don't. So they might be trying to understand what is out there. And if you just talk to them like a human being, it's really going to do you a lot of work, save you a lot of work down the line where they go, oh, you've just given me a copy of my health files. I already know what's in there. I want the correspondence between the doctors about me. There you go. If you just asked that question straight up, it would have saved you a lot of work early on.
Yeah. Don't be a dick. Don't hold information hostage. If someone hasn't paid a bill or done something that you don't like, just give them what you can as quickly as you can.
My other recommendation for us, if you do get to the stage of a complaint has been made, because Principle 6 is the easiest principle to get a complaint accepted to the Privacy Commissioner, all they need to show is a request has been made and some information has been withheld or refused, or they think some information hasn't been provided. And then we'll make preliminary inquiries or requests. It's going to save us and you so much time if you keep really good records about what searches you did, why you refused the requests, what questions you asked them, what correspondence you made, because otherwise you're going to get us asking you for that and you're going to have to go back through all sorts of things and go, oh, actually, I don't know why my staff member made this, sent them this response, withheld this information. Let me try and figure it out. So keep good records. It's going to save you a lot down the line.
Yeah. Question about whether investigators that are investigating cases that don't meet the threshold for police to take over. No, you probably can't use maintenance of the law. So what we would suggest is keeping good terms of reference right from the beginning. And this works a lot. We see this a lot too in employment investigations. We need the people who are collecting the information to set good terms of reference early. What is the purpose for which you are collecting information? Although you can't say that, we're not going to respond to a request if I get one in the terms of reference, you can be really clear and thoughtful about the purpose for which you're collecting information and think about the scope of who might be making requests for it afterwards. That'll make it easier if you do get a request to balance or consider what information they're entitled to.
There's a question here. Is there any preference in contacting requesters by writing or orally, i.e. by email versus a phone call?
Look, it's up to you. I normally do both. I would email someone and say, hey, when's a good time to call? Because that way it's kind of non-confronting and it gives them respect for their time, and you're not calling them on the hop, which might, you know, you might get them in an inconvenient time and inflame a situation that's on the borderline of, you know, turning icky.
The other thing is, if you do call them to explain your decision and reasons why you're withholding and talking about, make sure to follow up an email so there is a written record. So when if they do want to make a complaint, there is something for them to provide to our office or for them to go back and take a look at so they can know and remember what has gone on.
Yeah. Okay, in terms of proving what you did in an agency, it's hard to prove a negative where the requester is insistent that there is more information in existence and there absolutely isn't. Look, we hear you. we know that. Look, it's so hard, isn't it? I've investigated complaints where I literally took a complainant to the respondent agency's offices and sat there while the poor respondent scrolled through their data management system to show him that there wasn't any more files hiding. It is really hard. It is, and that's where it comes back to that relationship, right? You're like, if you have established a relationship of mutual trust and respect, it's going to be much easier to give someone an assurance that you really have had a girl look for the information that they're asking for. And sometimes you just have to use, it doesn't exist. And we see that. You'll be on shakier ground where there should have been. Do you know what I mean? Like sometimes we often see that a significant decision has been made about a person at a meeting and there were a number of people there and no one's kept a file note, even though there were some significant decisions made. So if remember as well that information does apply to, Principle 6 does apply to information held in the mind. So if Sarah and I had a performance management meeting and I failed to keep a record and she made a 6 request to me, I'd still probably have to write my notes down after. And I think there's some stuff about that in Turner as well. Great session. Thank you very much. How long do we hold the information of the requester? You mentioned about the record of the request, what search you used.
Be reasonable. Again, like no hard and fast answer, but if they're happy with the response, you can probably put that to the side because you're unlikely to get a complaint that's made through our office and going to have us coming back and asking you for it, right? If it's someone you have a really difficult relationship with, and regardless of what you do, they're going to make a complaint because they want that independent third party to review it to make sure that proper processes were followed. And yes, we know they exist, right? That's when you might want to keep that for a little bit longer.
Yeah, think about your other obligations and potentially in some cases statute of limitations, potentially, don't know, criminal liability. Okay, we've got a question about how do we envisage joint investigations with OAIC developing in practice? So we haven't done one in a long time, a joint investigation. Well, we did the IPCA investigation into the police photographs of rangatahi, and look, we don't know, we're not sure. We'll step it through. They've got kind of broader regulatory powers than we do, but also and in most cases, the agencies are probably based there rather than here. So, I mean, it'll just be baby steps, really, figuring it out. But we've got a really great relationship with the OAIC of, you know, we work together really well. We've got a lot of, you know, shared skills, but also, oh, look, I'm trying to sell it here. We don't know yet, but we're looking forward to figuring it out. I think that's it.
Yeah, we've still got a little bit more time, so throw any more questions that you might have into the chat box or that Q&A answer box. We're really happy to help.
Clarify Principle 6 includes what's held in your mind. Potentially, yes. So if you just went to our website and you can just put speech marks held in mind and they'll bring up a couple of case notes. But yes, if you are part of an agency and you hold information that the agency should reasonably hold, you can you should write it down. you should write it down and give it to them in the way that they prefer. I have had the pleasure of summonsing a respondent and questioning him under oath and gathering the personal information that he held in his mind. That was fun. So don't make us do that. Or maybe do. I don't know.
I guess something to remember with held in the mind is, again, it comes back to reasonableness. It is a good discussion in Turner about when information held in the mind may or may not be readily retrievable. As Riki mentioned earlier, if it's something that you should have been keeping notes about, then absolutely that's going to be something that's going to be requestable. If there's something which talks about go see Joe in HR about that, or Susan in whatever knows about that, again, that might be something where someone could get that note and go, oh, so what does Susan know about me? That's probably going to be retrievable, but asking someone just reasonably what everything is held, maybe not. Again, understand what they're wanting and just talk to them.
Yeah. No, we don't charge respondents to investigate complaints. Sometimes we wish we could, but no, we don't. So the kicker is though, is that if we investigate a complaint, so if we formally notify you either of an investigation or of an attempt to conciliate under Section 77, you are then open to the complainant pursuing the matter in the Human Rights Review Tribunal. So I guess that's the payment that you have to make, is the risk of litigation.
Does an urgent request have to be stated? So would you draw the inference from the 10 days?
They do actually say this in Turner. Where is it?
It's a good question. Riki will find the answer. I think, again, be reasonable. Don't go, oh, you didn't use the word urgent, so we're not going to do that. I don't think that's going to put you in good stead further down the line. If you want to seek clarification, I'd recommend just emailing them, say, hey, it's a 20-day working time frame. That is what we're working to. You've said 10 working days. Are you requesting this under urgency? And if so, why? I think that's probably...
Yeah, the question of urgency. Turn to paragraph 173 of Turner and the University of Otago, close brackets, 2021, NZHRRT 18.
And this will all be in the resources underneath the video when it goes live on YouTube.
Summarising the information, where to draw the line between summary and creating new info. Look, I mean, I think hopefully that should be obvious from the circumstances, but we're not expecting you to put anything in. But what is the Chartered Accountant's case? It does say that the information does have to be, what's the phrase that the tribunal used? You need to provide meaningful access. So if you do have to add in a couple of sentences to make sense of a summary, then that's probably okay. But you don't have to create a new summary of something that didn't exist before.
Summaries, yeah, and they're often a good, again, we will use them in many cases investigating a complaint as a ADR or resolution tool. Even if you are creating some new information, if it gets the complaint resolved and it means you don't end up in the tribunal, that might be just the way to go, right?
Yeah, and so we're not, I guess, information from someone's mind and creating new information. Yes, there could be some overlap there. Look, given the passage of time, exactly, you might remember things that you didn't remember at the time or invent things or whatever. So that's why keep good notes in the first place is always the preferred option. But you just have to provide meaningful access to information that exists. And that will sometimes be different in different circumstances.
When information is provided to a person who is conducting an investigation about bullying, can personal information subsequently be requested and withholding grounds be applied? I'm presuming how that's supposed to work.
Again, do good terms of reference so that, so example, the complainant knows exactly what they'll get, the accused bully knows exactly what they'll get, that witnesses know before you start questioning them about who's going to have access to that information, because you know that they might choose not to be involved if they know that their statements are going to be provided to either party. So be really clear about that from the beginning, and then just turn your mind to the withholding grounds. But terms of reference always what we look to first. And then there's going to be a lot of really sensitive personal information, mixed information in there. So it may be a case that you're redacting pretty heavily under 53B. Yeah. Okay, I think we've answered everything.
Yeah, unless there's any other questions coming through. Again, another plug for our website, our Ask Us tool, our principles 6 pages, our charging guidelines. A lot of work has been put into those. Our inquiries team, our call centre is great. Our assistant investigators are all fantastic. We're here to help. We don't want to make this hard for you guys. We want to assist you the best way we can, because, you know, if you can do a response right, it saves us work down the line as well. So it works out for everybody, and the requester goes away happy, which is ultimately what we're here to do, right?
Yeah, and it saves our very limited and meagre resources for matters where we actually can provide expert assistance and not just kind of hand-holding access requests. Thank you so much, everybody, for your excellent questions. Yeah, fun.
Very great. A lot of fun.
Let's do this again sometimes.
Yeah, so we're going to wrap up a few minutes early. So thank you all, and we'll catch you next time. Ka kite.